Okay, now we are on a final set of questions, and I do see a number of questions by you all, and we try to take them up right after this as well. So now coming and bringing everything together and discussing a bit more about specifically about the infrastructure sector and how financing or perhaps the key issues you see in the sector, which might be relevant for the audience to know about. As a small background, and of course, this is not going to be news for any of our audience members. Infrastructure projects globally are facing large-scale disruptions and disputes. This has meant the financial position of many construction firms has been negatively impacted in the absence of timely payments from their clients. The current situation does not help. The recent figures suggest over 59 lakh crores, that's almost $800 billion of projects being affected in India alone due to the COVID pandemic. And this is going to mean that the already financially strained infrastructure companies will have little or limited access to pursue their claims. So in that context, is litigation finance the savior? We've already heard the speakers on the key issues, the case considerations, on the various factors that affect litigation financing. And now we're going to discuss some of the nuances of the sector in a bit more detail. Alistair, coming straight to you first. Of course, a lot of the work you actually do is in the sector as well. So my first question to you is, what makes a sector unique or perhaps different from the other sectors? And particularly, what are the key issues and type of claims you observe in the disputes in the sector?
Well, Montek, the first thing to say is that infrastructure is a massive word to cover a huge number of different types of cases. And we can be talking about classic infrastructure like road and rail or air. We can be talking about energy infrastructure, and that's everything from sort of coal-fired power stations to hydro projects to offshore oil and gas pipelines, petrochemical plants and process plants, telecoms infrastructure. I won't go on. Point is, it can be a massive field, and it's wrong to try and generalize too much. However, let me do exactly that. Let me say first, it's a fabulous field. I get really excited by these cases. They are all fascinating. They're all technically challenging. They are never boring. But what sort of things define them? Well, they're typically large cases, often tens of millions, hundreds of millions. My largest case at the moment is getting on for $2 billion US. That's an infrastructure case. They are often complex, sometimes very complex and very technical indeed. And the technicality of the cases can be at a macro level, how a petrochemical plant works, how plant commissioning works, or they can be technical at a very micro level. How does the baggage screening system at an airport work? Or what is the detailed operation of the financial model for a toll road infrastructure project? On major infrastructure cases, typically the core issues are those of any construction project. 1, time and delay. 2, money and cost overrun. And 3, defects. Time, money, and defects are ultimately at the core of most construction cases. But infrastructure cases also have other dimensions to them which get equally or more interesting. There can be public sector, state, government dynamics to these cases if you're working under a concession or in a regulated environment. There can be, particularly in treaty cases, very interesting questions around government actions, commitments that governments may have given and changed, giving rise to treaty claims. Even in commercial arbitration claims, if you're dealing in any regulated or concessionary environment, there can be some very complicated questions around government. There can be interesting aspects around supply and offtake to infrastructure projects. An infrastructure project may need a long-term fuel supply or any other long-term input, and that can be quite innovative. If you're running a prison on some sort of a public-private partnership or project finance basis, you may need a guarantee of a certain number of people coming through the system to fill your prison cells. If you're running a hospital, you may need some sort of assurance about the referral of patients to that hospital. Anyway, the supply side of infrastructure projects can be interesting, and also the offtake side. a lot of disputes, including a number that I'm handling at the moment around power purchase agreements and gas. There's very, very big cases requiring an awful lot of time and attention. Massive numbers of documents to process them, and on top of that, some sort of a structured and cost-effective, which may need to engage specialist electronic document platforms, Relativity or whatever, and the use of those sorts of systems.
I think we are losing Alistair.
Yes, I think so.
I think we've lost Alistair. Should we move to Badri and come back to him when we get him back?
Come back to.
He's back.
Is he back? Can you hear us now? I think you're on mute, Alistair.
Clearly, the infrastructure wasn't up to it. I was just about to finish, actually. I was just going to make the obvious point that infrastructure cases typically can take quite a long time, probably longer than an ordinary commercial contract case, and they can often cost a lot more. And, you know, a very big infrastructure case, you're talking about costs, including expert costs and tribunal costs, that runs into millions, quite a lot of millions of dollars sometimes. So those are factors that funders are likely to be very focused on when they look at funding. But anyway, that's my comments around infrastructure cases generally. And my primary comment of all of them is how much I love working on them. Thank you.
Thanks very much, Alistair. It was a very helpful summary of the various issues you might come across. So now moving with that, it's a fantastic preamble to my question to Badri, you. Is now, first of all, of course, if you'd like to add to anything to Alistair's comments around the key issues which you have come across in the sector, specifically keeping the background of the Indian context here. And in your view, building on whatever we have spoken about today and the conversation we've had today, is the sector an ideal candidate for, and can it benefit from the use of litigation financing, specifically given the disruption we have seen over the last 90 days?
I think, Montague, you raised a very pertinent issue. I think infrastructure, call it by any name, whether it's a telecom, whether it's a oil and gas, whether it's a roads and buildings, whether it's any other types of infrastructure. I think everyone, there's a common one bottom line is that everybody is impacted very deeply and too much about it. I think the moment the COVID thing goes out, there are bound to be kind of a claims, counterclaims, things like that. And it's going to be kind of clogging the entire system with a kind of a cases. But be that as it may, let's talk on a standalone point of view. Today, infrastructure operates on very thin margins, as all of us know about it. We don't work for the profit part of it, but most of the infrastructure projects, they work for the repeated orders to stay in the market alive and to kind of have a kind of a goodwill that is generated. So when I'm answering my question, I would like to go behind the kind of the curtains that's beyond the kind of the infrastructure financing. I would like to go about it. The reputation is the key in this sector. Once we lose the reputation, however good the company, however good the balance sheet, we will not be invited to bid for the kind of a jobs as such. So the reputation is something which we always need to protect it. So when the finances are short in the hands of the infrastructure companies, they tend to prolong the kind of litigations or come with more and more claims, etc., etc. So there is a kind of an adverse climate that gets generated. So the intention of all the infrastructure companies is to ensure that they maintain their name and fame, to see that they get even some nominated jobs. I know for sure the companies with which I worked, which gets the jobs on nomination basis. It's a matter of a public knowledge, which you know about it. Okay, so that is the kind of an intention with every infrastructure company. To reach that kind of a goal, or to to reach that kind of a goal post in terms of getting the jobs and through goodwill and other means, I think the infrastructure financing is one of the best options. They need to really look at it. It helps them in two ways. One is that in terms of ring-fencing their kind of a budgetary allocation for the kind of the potential claims, disputes, and litigations which they foresee. And particularly in the sense of overseas litigations, if they have it, it's a huge cost impact. And sometimes it really swings the books the way in which we can't even predict about it. I think that's where the infrastructure companies need to take the kind of a cue in this financing. The second most important thing is that as we go along, it gives a kind of a sense of confidence that there is somebody behind me to going forward. So I can take a kind of an aggressive action in terms of moving and mobilizing my kind of a workforce and my work, rather than segregating this money for paying to my lawyer's fee or that of another fee, etc., which many a times it gets blocked. When we have some kind of a pool for one particular region, let's say eastern region or a southern region, let's say there is 100 crore allocation to the southern region for the projects, we suddenly take away about 20 crores because there are a couple of major litigations which are likely to come. We park that money out of it. So this really impacts a kind of a project. I think this kind of a third-party financing is the one which gives the kind of a push and pull. One, to secure the name of the company. Second is to go aggressively into the market. And three, build upon whatever we have built. It's definitely a kind of a positive sign. We should look at it.
Thank you very much. And that was very useful to hear. And I think one of the points you made about how it might affect your operational funding to pursue claims is also a very critical point. Now, coming to our funders. So Tom, to you first. What has your experience been specifically in the commercial infrastructure dispute space? And is it quite a substantial part of your overall portfolio as well?
It is, and it's a growing part of our portfolio. To make a few general comments about these types of cases, and I think Alistair has highlighted some of the key issues with it, and they apply equally from a funding perspective. You know, they are very technical cases. They're often very, very fact heavy, and that makes them difficult to assess. You've often got claims, you've got counterclaims and cross claims. You have, I think, often a tendency for claimants to inflate the value of amounts that they're claiming, and so. You know, when we are trying to look at things critically and saying, right, well, what is going to be the overall outcome here? It's a very difficult and complex exercise to undertake, and it often requires expert input. It requires a lot of work from the lawyers that we might be engaging as due diligence counsel, or the work we're doing internally, or indeed the lawyers that are running the case. To try and package it in a way where we can actually make sense of it. And Alistair's firm is particularly good at that, at analysing these cases where there are multiple, thousands of different possible permutations and outcomes, and distilling that down into something that's very digestible, not only for litigation funders, but for sort of board members and people with limited time. And that sort of approach to these cases is very useful. It helps us to assess them. But you can't get away from the fact that taking exposure to one infrastructure case often comes with significant risk. And so we prefer to wrap it together, if we can, in a portfolio with other cases so that we're diversifying our risk. And even better, if we can wrap it together with some awards which may have already been realised and are just waiting to be enforced. And the reality of the situation in India at the moment is that there are numerous organisations that do have a lot of claims, a lot of unpaid awards. And if they're clever, they can wrap those together and seek to monetise those in a way that benefit the business and allow them to pursue their cases. And we're indeed in deep due diligence on some of these opportunities. We have been, or we are funding Indian parties in offshore matters as well, and there has been an extraordinary amount of interest coming out of India, that has been driven by the infrastructure sector. But I would say, out of all of the applications in the Asia region for which I'm responsible, India is the lead jurisdiction in terms of numbers of applications. We receive applications every week, if not more than once a week, from India for applications for funding. And so, it is a very important market to us. It's part of the portfolio, but it's going to become an increasing part of the portfolio, and it's very interesting.
So just expanding on the last comment you were making. So so have you been? So I take it you have been funding Indian clients on an arbitration in the arbitrations, and just to get some more information on that as well. Are these mostly arbitrations seated outside India, or are you also looking at those now seated in India?
We're looking at cases in India as well. We're funding offshore cases, but we're looking at cases in India. We've yet to take one on, but it's certainly within the scope of what we're looking to do, and within the limits of being able to assess and fund these types of cases, because they are difficult, as I say.
Okay. And Sindhu, what has your experience been in this sector, and specifically anything around investment arbitration, which also end up seeing a lot of infrastructure assets?
So, so the teams worked on, and I think continues to work on, investment claims if you're coming out of the infrastructure sector. And these are a variety of, infrastructure claims, either coming out of the oil and gas sector or more traditional construction sector. And the jurisdictions involved are, West African jurisdictions to, the usual Middle East suspects, the CIS region as well. They're not all structured as treaty claims. Some are as sort of concession grounds being expropriated or FET claims, but many that we see are just structured as commercial arbitration claims, delay, disruption, wrongful termination, and so on. In terms of India, we would certainly consider claims by Indian claimants. I can't actually think of too many funders nowadays who wouldn't. And then with I suppose your question to Tom in terms of India seated foreign seated arbitrations as well. It's I personally, I've watched with growing interest all the reforms that have been taking place with respect to international arbitration seated in India, both with respect to timelines, with respect to what's going on with Section 34 challenges and no automatic stays on enforcement. And I think there's only going to be growing interest from international funders in this space. There are challenges, with whether it's with structuring, which is we've touched upon before, with enforcement, and just wrapping your head around, I think, the way the Indian legal system works. But I think you're going to get more and more interest, particularly from funders who've got a good grasp and a good understanding of the Indian legal system.
Thank you. That is very useful to know, I'm sure. So the audience will also be looking forward to talking to you, both of you, in more detail in the coming days and months. Final question to you, Prateek, just wrapping it up from an Indian perspective. What has your experience been of using or considering litigation financing in the Indian context? You're on mute. Prateek, you're on mute.
Just to point out, litigation finance is pretty confidential, and things are not available in the market. But that said, there are a few deals which you hear about. Of course, Patel and HCC are pretty widely publicized deals, and those are the two big infrastructure deals which everyone knows and are talking about, Patel Engineering and HCC. But besides that, at least to my knowledge, I have seen around 7 to 8 deals in the market, not only as Singularity, but as other organizations or other law firms I hear from. There are at least 7 or 8 deals I know in the market. This includes funding of offshore litigations. This includes India-seated arbitration. This includes portfolio claims. Large construction clients looking at 10s and 15 cases bundled together, all India-seated, including awards. So there is a mix. The banks are playing a big role. Financial institutions, they are going to funders and deciding if they can take up their bad apples and try to make them into good apples. We've been involved in those kind of deals as well. So I would say a lot of activity is happening while it is nascent as yet, but I wouldn't say it's far away from where Singapore or Hong Kong is. The last 2 or 3 years has been very exciting. And it's something which is picking up. We regularly are seeing funders who want to explore the Indian market, who want to enter into the Indian market, who always say that we get the maximum amount of entries, like Tom pointed out, from India. So there are many big funders on this call, if you will see, and that clearly shows the interest. Say that the deal flow today would be around 7 to 10 deals, roughly in the range of $2 to $3 billion transactions. But this is a tip of the iceberg. What we are going to see in the future, in the next 4 or 5 years, we're looking at least $30-40 billion of disputes funded and run. Of course, for that, the courts, the board, as Badri pointed out, the banking, financial institutions, the lawyers have to step up their game. And we need to ensure that the funder gets their return. And I think that's going to lead to a lot of deal flow in the Indian market.
Thank you very much. And with that, we come to an end of at least of our predefined themes, which we want to touch upon. And we have a few minutes left, and I'm going to take that opportunity to ask a few questions. There have been many questions being asked as we were speaking. Unfortunately, I don't think we'll be able to cover all the questions. We'll take away perhaps 5 or 6 questions and then call it a day. But we'll look to answer the remaining questions by email after the conclusion of the webinar. So I'll start off the first two, and then Prateek will then take the next two. And this was a common question I came across in the Q&A section. And I'm going to combine the few questions which touch upon the same topic. The theme of the question was, is there a size, a particular size of claim you look at, or minimum value of claim you look at? And a second part of the question is, the preferred type of disputes for funders to look at, and specifically within the infrastructure projects, for example, road construction versus port versus real estate. So type of disputes and the quantum of the disputes. What are your comments on that, both Tom and Sindhu?
Shall I go first, Tom?
Yeah, go on.
In terms of the minimum value of the dispute or the maximum value of the dispute, I think it varies funder to funder. There's no sort of right or wrong value, generally speaking. For us, we tend to prefer the larger claims. Without putting an absolute number to it, I would say we tend to prefer the sort of tens of thousands of crores, as Badri mentioned earlier, which infrastructure I think is quite ideally suited for. Types of disputes, we've really got no preference. We look at it on a case-by-case basis.
Yeah, and we perhaps have a bit more flexibility on quantum. We're typically looking at arbitration cases, international arbitration cases, especially with Indian parties. And if we're looking to try and achieve our 10-to-1 ratio in those circumstances, taking into the account the usual costs of arbitration, it tends to mean that we're looking at cases with a value of $10 million and above, at least. And so there is that sort of natural minimum. In terms of cases that we like, as I said earlier, the very fact-heavy and technical cases are very difficult to assess. Within the infrastructure dispute context, there are some quite interesting angles in which a funder can gain exposure without taking on the risks associated with the technical and factual aspects of the dispute. One example is under many construction contracts and the sort of the standard form FIDIC contracts. If you have a DBA award or an engineer's award, there is often an obligation on the person due to pay under that award to pay pending any further arbitration or dispute. And you might want to bring in a funder to fund a preliminary action to seek an award payment of that amount, which, if you can enforce it, should provide some cash flow to then fund the remainder of the proceedings. So that's one sort of side issue that you could potentially bring a funder in without having to expose them to the broader issues in the case. One other issue that's come up recently for us is looking at releasing an injunction order over a performance guarantee, and allowing one party to draw down on that guarantee, and therefore they have the funds available to pursue the case. So that, there are just quite neat side issues in the context of these disputes, which we can get involved in without having to understand all of the factual and technical nuances.
Thank you. The second sort of theme which you can observe from the Q&A is it's about the control funders might have. And it'd be good to get some thoughts both from the funders as well, but also Alistair, from you, if you've seen any, have an experience with funders perhaps taking more control on certain matters. So first, I guess back to you, Tom and Sindhu, is usually what's your strategy on amount of control you have, including in the appointment of counsels or experts or driving settlement negotiations? So perhaps the same order. Sindhu, you can go first. And then
I mean, we're based out of London, and in some ways we're subject to exactly, or we follow exactly the same rules. Prateek outlined earlier in terms of control. We don't seek to exercise control over the litigation. It stays with the claimant. I mean, that said, there is an investment that we've made, and we will, project manage the dispute or look at what's going on with that investment to make sure that our returns, as well as the returns of the claimants, are sort of not being compromised, and that usually entails the law firm as well as the claimants just keeping us in the loop in terms of what's going on with the litigation. And more often than not, I think there's less an element of control, but both the law firms as well as claimants, I think, value our input on things such as key strategic decisions that they need to take in a case, whether to bring, so-and-so application or how to approach settlement negotiations. I mean, the inputs of the fund are actually quite valued. And that's really it. And in terms of counsel selection, I think it really depends on the type of dispute and the way in which it's been developed and brought to us. So obviously, more often than not, you see, particularly in the commercial litigation arbitration scenario, you'll see, claimants already gone to a law firm. They've worked it up. They've worked out that they will either benefit from funding or they need funding, and then you get a package deal. You get a counsel team plus you get the case. And in those cases, it would be quite rare for a funder to try and sort of influence or tell the claimant to choose another lawyer. Then, of course, you've got opportunities that you sort of develop with claimants on your own, and this is something we see. I mean, we fund and we're big funders of class actions in the UK, and those work a little bit differently. We put in a fair bit of effort into developing the opportunity upfront, and in those cases, obviously, it's probably the funder that's selected the counsel and has worked with counsel in order to develop the opportunity ground up.
I think thanks for that, Sindhu. And I'm going to be getting into more specific questions, people by name and address itself. And there are very interesting questions. There is a question from Mr. Shamik Roy, who is the COO of an ARC, an asset reconstruction company. And his question is to the funders here. Asset reconstruction companies acquire debts of stressed assets, stressed EPC companies on assignment basis. Would funders be willing to look at claims and awards of such debts which have been acquired by asset reconstruction companies? I guess first Sindhu and then Tom.
Yes.
Tom?
Yes. I mean, so long as you can find the interest in them, then we would be interested.
The next question is from Mr. Adit Mittal from Mercator. And his question is with regards to the funders' experience here working with Indian PSUs and, of course, the success rate in the last 3 years. His specific question is that with funders in place, would a PSU come to settle a case in your experience?
I don't have specific experience to really comment on that, I'm afraid.
And then
What about
same here.
all right.
I think Badri may have something to say.
Badri, anything to say on that?
I don't think so. It's not correct. With the funders, the PSUs will not come in to settle the things which we expect it to be settled. That's a short answer I can give it, for various reasons, which we are all aware about it.
Two more questions, one for Alistair and one for Badri. Alistair, so this is a very interesting question from Jui Bal. It relates to something which you spoke about on a quantum expert being involved in presenting a case to the funder. And their question to you is, would you see this impinging the independence of the funder? And would it be able to still present an independent view before the tribunal, having assisted a party in acquiring funding?
Right. Would it affect the independence of the expert? You would have to be careful. You would have to make sure that that expert is still giving their opinion as an independent expert. And in fact, you know, if I go back to a comment that I think it was Tom made, which is that he'd much rather come and hear about, he'd much rather people came and told him about the case warts and all than to dress it up in bows and ribbons and make it look beautiful. Funders are going to find it much more useful to have the independent opinion of an expert than to have a hired gun who comes in and sells a particular story. So I don't think that the independence of the expert is necessarily compromised simply because that opinion is given in the context of applying for funding, as long as it is clear in the expert's instructions and apparent in the delivery of the report that it is an independent expert report.
Right. And Badri, to you, the question is, and especially this is in the context of NHAI claims, where NHAI has now come up with a policy to settle 75% of bank guarantee dispute claims and pay out money. And the question is, does this make it attractive for funding, this policy by NHAI?
Looks like on the face of it, yes, it's a kind of a very encouraging step on their part. But we need to see into the kind of a fine tuning as to how it would go. Whatever the policy decisions are announced by NHAI, many times it's difficult to follow through. And let's see, probably this could be one of the steps, but this is certainly in the positive direction.
Okay, we're going to have the last two questions of the day, and I'm really sorry for the ones who we could not address. One question is, of course, to Montec, and this comes from Arvind from IMF, Omni Bridgeway, I would say. Montec, the question from Arvind is, how would COVID pandemic affect calculation of gross profit of claims? Would it operate as a ceiling cap, or would one apply some sort of discount? Charge him for this answer.
So I hope Tom's not a planted question to get me off hook. Unfortunately, the answer will be very, very long, and we don't have the time for that. But I think in short, what I can say is COVID has thrown different challenges to calculation of losses, and the evolution of data we are seeing on a daily basis is quite high. I think the themes which are coming across quite clearly is, first of all, there's going to be obviously a substantial short-term effect of the crisis, both on the demand side and the supply side, which I think any value or an expert has to be very careful about and make sure that's addressed properly when calculating damages. The second is there is uncertainty on the medium and long-term effects. But again, I think a value will need to properly consider scenarios and probability adjusted scenarios on the likely evolution of the business which is under contention, or the contract which has been disputed, and how that contract, the business might have evolved in the medium to long term. And I think thirdly, and I think this is quite safe to say, is the risk higher today than it was December 31st, 2019? Absolutely, yes. But is the increase in risk similar for all businesses? No. So you've seen technology businesses and FMCG businesses still do well to some regard, but you've obviously seen infrastructure companies and real estate businesses being quite significantly affected by the current crisis. So I think in short, it's going to cause a deeper analysis of the fundamentals of the business and how they've been affected by the COVID pandemic. It'll require proper assessment of the risks attaching to any profit forecast you make today. And when you say, would it apply as operators in ceiling or a cap? I don't know the answer to that. I think it depends on the business you're in. But I think a discount or a proper evaluation of the discount is going to be quite necessary. And I think the risk must be properly weighed and incorporated in your calculations if they're performed during the current period.
All right, so this brings us to the last question of the day, and it's a split question to Tom and Alistair. And it's a very, very interesting question from Daniel Ang. Very recent regulations made reference to here. And the question is, for a regulation of a third-party funder in particular, do you think the existence of the existing financial service regulation should be extended to them, number one? And number two, can we draw from the experience in pioneering jurisdictions like Australia, which has oscillated between a financial service license and not allowing TPFs to hold them? First, Alistair, and then Tom.
Pratika, I'm going to duck that question because I'm actually not sure that I know the answer. I'm not going to tell you that I know very much about financial services regulation, and certainly not as it applies to third-party funds. I could speculate as to what my answer might be, but I don't think 200 people on this call want to hear me speculating when they've got experts on the call who can tell you what they think from an industry insider. So excuse me for ducking it, but that's what I'll do.
Tom, it's on you then. And maybe Sindhu, you can add a couple of points from your experience if you have any on this.
Obviously, it's a very topical issue in Australia at the moment. We previously had to have a financial services license in Australia, that was required, and we obtained one. They then just pause for the thunder and lightning. The rules then shifted, and we weren't required to, and we were excluded from the organisations that had to hold a licence. And now the proposal is that we should again. From our perspective, we welcome that. We think that some appropriate regulation of third-party funders is appropriate. One of our largest concerns is that I think someone referred to cowboys getting into the market earlier in this presentation. One of our concerns is that does happen, and that creates a bad reputation for the entire industry that we've spent decades building up in an ethical and transparent way. So that's our view. I don't want to get into too much more detail about this. But yeah, we would welcome the right sort of regulation. I think if it is going to be introduced, it's important that regulators are consulting with funders and relevant stakeholders to make sure that we get it right. But as a concept, we wouldn't resist it.
Well, it's very interesting to hear because we do advise this to funders in India as well, that if they come on shore, they might need a license, and especially they might need to set up certain regulated funds like an IAF fund or something equivalent where you would need to take license from the RBI or at least some regulator in place. But Sindhu, what do you think about this financial service license to funders?
I mean, I don't claim to know too much about the Australian system, but in principle, we wouldn't be able to regulation at all. In the UK, obviously, self-regulation model, we've got a voluntary association, the Association of Litigation Funders, who've and its members follow certain rules, including on the amount of capital that they have to protect against the risk that you both identified in terms of cowboys entering the market, and various other things just in terms of the conduct of the litigation and things that protect the claimant. We are members of the ALF, and I think if at some stage regulation moves more from self-regulation to explicit regulation, I can't see why any funder, frankly, who's on the who attempts to, I think, broadly, work this business in the interests of the claimants and in the interest of justice more broadly, would oppose it.
Thank you. Thank you very much for that. With that, we'll call it a close, but a special thank you to all the panelists and specifically Tom and Alistair. It's quite late in Singapore. Thank you very much for staying back. And thank you to the audience who stuck around for the over 2-hour session. We will try to get the answers on the pending questions to you by email. But again, thank you everyone. Thank you very much for your insights and discussion today.
Thank you, everybody.
Thank you, everybody.
Thank you, everybody.
Thank you.
Bye-bye. Thank you.